So I don't. Hey, good morning, everyone. My name is John Hurley. I'm your judge this morning. Is my plate in?
Yes.
I'm your judge this morning. Hey, good morning, sir. We're in first appearance court. Today is the day the court determines whether or not there's probable cause for your arrest. We're not here for a trial. We're not here to show that you're guilty or not guilty. It's not for today. Therefore, you do not need to tell us what did or did not occur regarding your arrest. Please save that for your attorney in a private meeting. Call it up if you have a private attorney. Let me know who that is. We'll contact your attorney and let them know that you're in court this morning. Remember, everything's being recorded. If you decide to speak about your case, any of the facts of your case, the prosecutor can easily get a copy of this video and play it for a jury one day, and I can assure you that most of the time you'd be very disappointed that they did that. So please do not tell me anything about your case. Today's not the day for it. Now, when I do call your name, if it's a nonviolent crime and it's either a third-degree felony or a misdemeanor, if I ask you what your address is, I'm asking to confirm so we know you're going to get your mail, and I'm probably going to release you without giving you a bond. But we'll get to that down the road. Are you Jorge Laredo?
Yes, Judge.
Hey,
Yes,
good
sir.
morning, Mr. Laredo. We have an attorney here on your behalf.
Huda Ajlani on behalf of Mr. Laredo, and Gina Laredo is present as well.
Okay. Good morning, both. You have two attorneys, sir. Here for you. You've been charged with four counts of battery, one count of battery on a police officer firefighter. Do you have any objection about probable cause today?
There's no PC objection.
Okay. State any priors?
Your Honor, in the mid-'90s, Mr. Laredo had a federal prior for possession of marijuana with intent to sell or distribute. It appears that he was placed on probation, and it does appear he received an early termination.
Okay. Let me get a sidebar real quick. You stay right there. So I'm going to release you today on your own recognizance, but there's going to be a few rules. Number one is you're not allowed to go into a casino. You're not allowed to go to a freestanding bar. You can go to a restaurant that has a bar, but you can't go to a freestanding bar. You can't go to a casino. You're not allowed to consume any alcoholic beverages while you're on release. Not a drop. You're going to have to report your pretrial release on Monday before noontime, which is right across the street. And you're going to be subject to random testing for drugs and alcohol. And I'm going to order.
Judge, with in terms of random drugs and alcohol, he does have prescriptions, and we'll make sure that pretrial
That's
gets
fine.
a copy
It's
of that.
cleared. And the court's also going to order that he attend at least one Alcoholics Anonymous meeting per week while he's out. Okay?
Your Honor, the only other thing I'd request, in addition to the general no bars, no casinos, specifically, I would just ask if you could order him not to return to the Hollywood Hard Rock property.
You're not allowed to, obviously, sir, no casinos, no freestanding bars. That includes Seminole Hard Rock, all their properties, all the other casinos we have here in South Florida. You're not allowed to go. Is that understood, Mr. Laredo?
Yes, sir.
Okay, thank you. He's going to be released on his own recognizance, right? Yeah, on Monday. Thank
Judge,
you. Yes.
May I call just one case out of turn? Williamson, Sean T. Williamson at North Broward. Bat Leo.
It's more for his benefit. I just don't want to see some confusion. It's like, well, he didn't say I can go to. Oh, of course.
Go ahead, state this. Good morning, Miss Williamson.
Hi, good morning.
Miss Williamson, you've been charged with battery on a police officer. Court finds probable cause.
Okay.
State, do we have a criminal record on Miss Williamson?
Your Honor, let me just check. Okay. Yeah, the only thing I'm showing, Your Honor, sorry.
Miss Williamson, are you going to live on 60th Avenue in Tamarack when you leave?
I'm probably gonna stay with my mom for a while.
Is that her address I just gave you?
No, that's my dad. That's where my dad lives.
But you talk to your dad and you get mail there, right?
No, I don't get mail there.
Well, if you did get mail there, would your dad? Do you talk to your dad? Would your dad tell you you got mail?
Yeah.
Okay, got it. See?
She's got a non-expiring injunction that was ordered against her pretty recently. It was granted January 19th.
Okay.
I'm sorry, my mistake, January 19th of last year, so it's...
Okay, ma'am, I'm going to go ahead. I'm going to set your bond at $1,000 based on the facts of the case. Ma'am, I'm going to order that, that's it. Bond's $1,000. I think your family's going to bond you out, all right, ma'am?
All right, thank you.
Yes, ma'am. Okay, let's call up Jessica Noel. Jessica Noel.
Who's this?
Jessica Noel here present, Judge?
Hello, Mr. Well. You've been charged with burglary of a dwelling and a battery. And let me just take a look here. Okay. Hi there. Okay. Sure. Hold on one moment here. Okay. Wait. I'm sure I'm doing this right here.
Keep a wire.
System on. Okay. Now, do you have any prior state?
The only thing I see, and I'm only mentioning this because this appears to be a familiar situation to some degree, there was a battery arrest in 2012 in Boynton Beach that was dropped.
Okay. What do you think about bond or release conditions, state? Do you have any?
Your Honor, it is, and I would note that there is an independent witness to this. I would ask that some bond be imposed. I'm not asking for a significant bond.
Right.
And obviously, no victim contact.
Okay. I'm going to go ahead and
Judge.
go ahead, sir. I'm going to go ahead and release her without bond. All right.
Thank you very much.
I'm going
Appreciate
to
it.
release her without bond, but I'm going to order though that she is not allowed to have any contact with. What's the grandfather's name?
It is
I didn't see it here.
I have it here.
It's blacked out.
I have it here. Rodney Disgraves, Your Honor.
Rodney who?
Disgraves. D-E-S.
Rodney Disgraves. You're not allowed to contact with him. You must stay 500 feet from him at all times. You're not allowed to possess any guns or weapons while you're on release. All right, ma'am?
Okay, thank you, Your Honor.
Thank you. Thank you. All right. Now, let's see here. Try to get myself organized here. Okay, may I see Rosalind Michelle? Rosalind Michelle?
Rosalind Michelle is here, present main judge. Come on up, Miss Michelle.
Michelle, Miss Michelle, you've been charged with domestic battery. Court finds probable cause state. Do we have any criminal on Miss Michelle?
One moment, Your Honor.
Good morning, ma'am. Ma'am, I see your residence is on 33rd Street, Miramar. Do you have somewhere else you can stay for the time being? Do you have a family member or somewhere you can go?
I have nobody.
Do you have any friends? Do you have a friend?
No, I have nobody.
Your Honor, I've had an opportunity to speak with Miss Michelle. My understanding is when she was arrested yesterday, I believe her husband's the alleged victim. The husband's daughter actually came to pick him up, and they removed all their belongings from the home. So from our belief, the actual husband did leave the household. I did advise, though,
Okay.
Miss Michelle, typically on domestic situations, you order no contact, for her not to have any sort of contact. So if he actually went back, then she is aware
Right.
that she's not supposed to have any contact. But as far as we know, he moved out. Judge, in talking about Miss Michelle,
Oh,
she's
just give me a
35.
moment. Just hold on.
Okay.
State of the priors.
2002 out of Miami-Dade. 2 counts. She pled 2 counts of child abuse, 1 count of child neglect.
Ma'am, I'm going to release you on your own order. You don't have any contact with Eves Dorsey. Do not have any contact with him. Stay 500 feet from him at all times. You're not allowed to possess any guns or weapons while you're on release. Thank you, ma'am.
Thank you, Judge.
Okay, may I see Lionel Johnson, please?
Mr. Johnson, come on up, please.
Mr. Johnson, domestic battery, sir. The court finds probable cause. Steve, do we have a criminal record on this gentleman?
One moment, Judge.
Do you have anything you'd like to add, sir?
Yes, Judge. In speaking with Mr. Johnson, he's been residing in our community 34 years, his whole life. He is employed. He works for Florida Home Development. He works at the call center. He makes about $10 an hour. Financially, he has no money in the bank. He does have a separate place to live other than with the alleged victim, separate and apart. He will be going ahead and staying with his brother. Judge, I believe they share 4 children in common. We'd ask you to allow through third-person contact to arrange for child care, custody visitations, and also we'd be requesting a phone order so that Mr. Johnson could go ahead and find a contact number for purposes of bond. We'd ask you to set a reasonable bond as to Mr. Johnson.
Got it.
2010 out of Miami-Dade, he was arrested for battery. That was dropped. 2006 out of Hendry County, manslaughter. Sentenced to 7-year state prison.
Okay. Ma'am, did you have any contact with the alleged victim?
I did. She just stated that he needs to just go on with his life without her.
Next one's out on bond.
Yeah, I know.
Got it. Okay. Sir, I did note the facts of the case. Allegedly, you allegedly roughed up a female, bit her on the left shoulder, scratch mark on the side of her cheek. The court's going to consider the level of violence. You do have a prior manslaughter. Court's setting your bond today at $7,500. I'm going to order a pretrial release with a GPS monitor. I will waive the cost of that monitor. I'm going to order you have no direct contact with Samantha Love. No contact with her directly. You must stay 500 feet from her at all times. You're not allowed to possess any guns, any weapons, any firearms, but the court will allow indirect contact regarding the children, financial support, care of the children. You can go through a third party for that. Thank you, sir.
And Judge, would you sign a phone order?
Yes, I will.
Thank you.
Nixon Ward.
Mr. Ward, come on up, please.
Ma'am, do you need me for something?
My daughter, Shanti Williamson.
Okay.
We just called the case, ma'am. The judge said $1,000 bond.
Oh, we did?
Yeah.
Is that a
Hold on
bond
one-
you can afford?
Hold on one
She
moment.
told.
Okay, just right there. That's fine. Ma'am, tell us your name.
Jennifer Barrett?
And you're the mother of Shanti, right?
Yes.
Okay. I set her out on a $1,000 bond.
Could you do it a little less? That's a lot.
Well, it's actually kind of a low, very low bond. It would be basically, from what I understand, $100 to a bail bondsman. So,
Okay.
what do you do for work?
I'm a nurse's aide.
Are you? Are you going to have Shanti come to your stay with you?
She lives with me.
Okay, does she? From what I understand, there's some mental health issues.
Yes, there is.
Are you concerned about your safety?
No, but I wanted her to go to
A facility for
in
mental?
the daytime, to sort of get her,
Well, at this stage today, I don't have the resources to do that, but that can possibly be done once she gets to her trial court. All right. So, did she have any priors?
Just an injunction.
Can you afford $100 to her husband? She told me she would bond her. Can you afford that, or will the court consider
I'm gonna go back to Shanti. I'm gonna release her ROR. All right, ma'am. I'll release it without a bond. Okay?
Thank you so much.
Yes, ma'am. Okay. Good luck. All right.
Thank you.
Just I wish you the best. Okay?
Okay, thank you.
Yes, ma'am. May I see Nixon Ward, please? Nixon Ward. Come on up.
Mr. Ward, come on up, please.
Mr. Ward, you've been charged with violating an injunction. The active injunction is case number 16-01470. It says CF10A. So
Your Honor, yes.
that must be a stay away order, right?
It's a no contact order from a pending, he's charged with 1 count of aggravated battery, 1 count of battery, same alleged victim. He's out on a $60,000 bond.
Case number?
16-14702, CF10A. And Your Honor, can I advise the court of his record for bond purposes? He was arrested last year for aggravated battery, deadly weapon, ag assault with a deadly weapon, and felony battery due to priors. That wasn't against Ms. Bellamy. That was against, I believe, her cousins. I remember the case. It was dropped, though. He was arrested for aggravated battery, pregnant victim last year against Ms. Bellamy. That was dropped. Arrested last year on another aggravated battery, pregnant victim against Ms. Bellamy. That was dropped. He was convicted of, one moment, domestic violence battery in 2015 against a different alleged victim. One moment. Had another battery that was dropped in '04.
So I'm going to assume you have no money and you have excellent ties to the community. I'm going to set your bond today, $7,500. I'm going to order that you have no contact directly or indirectly with Miss Antoya Bellamy. You must stay 500 feet from her at all times, where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns or weapons if you make bond. Sir, the court already knows you've been convicted of 1 domestic battery. Assuming you have no money and excellent ties, the court will revoke your bond on 16-14702. CF10A, you'll be held without bond until further order of the court. Thank you.
Okay.
Okay. Now, Leonardo Florantes.
Mr. Florantes is here, President Main Judge.
You sure about that?
Okay.
There's no prost. I'm showing there's no prost.
Hold on one sec. All right, here we go. Leonardo Floranta, sir, assault, domestic violence related. Court finds probable cause. And State, do we have a criminal record on this gentleman?
Any other records? Your Honor, he had a burglary of a dwelling with a battery arrest last year against a different alleged woman. That was just null prost about a month ago.
Got it. That was an aggravated battery on another female?
No, burg dwelling with battery.
Got it, okay. Was there any contact with the alleged victim on this matter?
Yes, Your Honor. She did say that she was fearful and that he's
Okay.
been threatening her.
I got it, okay. Anything from the defense on this defendant?
Yes, Judge. He's been residing in South Florida for 5 years now. He is working, works part-time at Willie Wood Retirement Home. He's a server. He's been working there for about 1 month. Financially, he has no money in the bank, no property. He makes $8.05 an hour. My understanding, he lives with his father in Pompano. I believe the alleged victim lives with her own mother. He's also currently going to school. He goes to Florida Career College, pursuing a medical assistant degree. Judge, we'd be asking you to set a reasonable bond as for Ms. Florentis.
Ma'am, remind me, was there contact or no contact?
Yes, Your Honor.
And what was the contact?
She's fearful.
She's fearful?
There's been threats,
Yeah.
before
He's been
this.
threatening her in the past.
Really? Okay.
Continuously.
Sir, I'm going to set your bond today at $5,000. It's based on the level of violence, the court's concern for the safety of the alleged victim. The court notes the facts relied on in this. Allegedly, there was an attempt to choke her with a wire. And, sir, I'm going to order that you have no contact with the alleged victim. Ms. Latoya Lee, no contact with her directly or indirectly. Sir, I have been told that there have been some threats made somewhere along the line here. Please do not have any contact with her directly or indirectly, because if you do and the court finds out, most likely your bond will be revoked and you'll be held in custody. You must stay 500 feet from Ms. Lee, where she lives, works, goes to school, anywhere in between, and you are not allowed to possess any guns, any firearms, any weapons while you're on release. Thank you. May I see Anton Ward?
Mr. Ward, come on up, please.
Okay, Mr. Ward, count 1 is domestic battery. Count 2 is cannabis. Court's going to find probable cause to count 1, count 2. Hold on one moment. Go ahead. Did you?
I miss it. Sometimes people miss it.
All right. What was your objection there, Mr. Elson?
No testing, Your Honor.
All right, I agree. All right, so count 2, there's no PC for the cannabis. All right, does this defendant have any priors?
Your Honor, obtaining control 12 with a violation of probation. Burglary of a dwelling and felony theft 2012 with a violation of probation. Theft 2012, possession of cocaine 2010 with a violation of probation. Possession of cocaine 08. Delivery of cocaine 06. 17-month state prison as a habitual offender. Unlawful use of false name ID 05. Grand theft auto 04 with the VOP. Theft 04. Possession of cocaine 02. Delivery of coke. Okay.
Okay.
There was also an investigation for aggravated battery in 95 that was dropped.
I got it. Okay. Now, anything? Was there any contact with the alleged victim, ma'am?
No, Your Honor.
Okay. Anything from the
Judge?
defense?
Yes. He's been residing in South Florida his whole life. He's 44 years old. He works at Labor Ready. He's been employed with the same company for over a year. He makes about $9 an hour. He has no money in the bank, no property. He was residing with the alleged victim, but now he knows, I've explained to him, most likely no contact order. He did advise me he has a separate place to live, separate and apart from the alleged victim. We'd be asking you to set a reasonable bond as to count 1, Judge.
Okay. Count 1's going to be $1,000. Count 2, ROR. And the court notes the level of violence. But I'm going to order, sir, that you have no contact with April Stout. Don't have any contact with her. Stay 500 feet from her at all times. That's where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns, weapons, firearms, or ammunition while you're on release. Thank you, sir. Ma'am, may I help you? Are you here on a case?
No, sir. My son was brought in this morning, well, he was brought in last night, he had an 8:30 court appearance.
How old is your son?
38.
Okay, what's his name?
Michael Monteo.
Michael
Monteo.
Michael Monteo?
Yes, they called me and told me that
Okay.
he had.
I think he's here. Hold
He's
on.
here present. Michael Mateo.
Just give me a moment. Okay, stand by 1 minute. Let me find the paperwork, all right? Okay, don't worry. Don't worry, we'll take care of it.
Okay, thank you.
Let me find the paperwork here.
He's on page 22 of the docket on new law offense. Wait, hold on now. That's not him.
I've got it. Okay,
No,
ma'am,
that's
raise
not
your
it.
right hand.
I'm sorry?
Raise your right hand. Swear or affirm. Tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, put your hand down. Tell me your name.
Deborah Monteo,
Okay, you're the mother of Michael.
mother of Michael Monteo.
Okay, thanks for coming in today. I'm sure it wasn't the best experience, but I'm glad you're here. So, Mr. Monteo, you've been charged with a battery, not domestic, I'm sorry, a simple battery. I'm looking at I believe your son's a basketball coach, right?
No, my younger son is the basketball coach, and we were attending the basketball game last night.
Yeah, it says right here, a fight broke out between Dillard High School boys basketball
Right.
and MacArthur boys basketball.
Right.
And it says at some point, your son,
No, Michael is not a coach.
your son punched out a player for Dillard High School, knocked him out onto the floor from the punch, and it says your son's the assistant coach for the MacArthur boys basketball team.
No, he's not a coach at all. I don't know where they got that information from.
Okay. All right. Let me state, is there a criminal record here?
I don't see it, Your Honor.
What does your son do for work?
He's a security, he works security.
Okay. All right. And does he live with you?
No, he lives with his brother.
Okay.
He lives with my other son.
How long does he live down here in South Florida?
Oh, he was born here.
Okay. And what do you do for work, ma'am?
I'm sorry?
Are you working?
I'm retired from the Pembroke Pines Police Department.
Oh, really? What'd you do there?
I worked in administration with the chief and the assistant chief.
Great. All right. Well, I'm inclined to give him a bond, a minimal bond. $1,000 bond, I think, is reasonable under the circumstance. That's really that was a standard bond anyway. That's a very low bond. So just ask him not to attend basketball games
Right.
for the time being.
And
Don't attend MacArthur or Dillard basketball games.
Your Honor, I would just ask him.
I don't know. The alleged victim is a high schooler who's got the initials of DV. No contact with the high schooler named DV.
That takes care of it.
Delta Victor. No contact. I'm sure you want to have contact anyway, but stay away from it. He'll get
Judge,
notice.
Mr. Moncoy has no problem abiding by whatever court order. He knows not to have any sort of contact. He did previously speak with his mom. His mom's in a position to financially post his bond.
Okay.
And as the state confirmed, this is his first arrest ever in his life.
Got it. Okay, no problem. Good luck, ma'am.
Terrible experience.
Thank you,
Bye now.
Judge.
Were you there?
Yes.
Okay. Well,
See, what happened was the kids
Ma'am,
started
don't talk about the
fighting.
Right.
So my son, that's the coach for the JV
Right.
team, and my older son, Michael, was trying to break up the
Break it up.
fight. So Michael went behind the young man and grabbed him and pulled him off of
Right.
our kids. And all the bench for Dillard cleared, and they were
yeah.
coming
When I
over.
read it, it looked like kind of turned into a melee. So.
Right, and Michael said that they were punching him in the back of the head.
Right. Well,
And
you know
he
what though?
turned around and
Without getting too deep into this, there's going to be a time if you want to go out and hire an attorney, you can do that. Hire a private attorney if he feels like it. But there's going to be a time that this will get ironed out in another courtroom. He doesn't come back here. I'm just the first day judge.
okay.
But he's going to get notice to come back to another judge at the other side of the courthouse in the next month or so. All right?
Okay, now I went over there to pay the bond, and they wouldn't take it because they said
They'll
it's
do
not,
it now.
it's not updated.
It's in the computer now.
Okay, thank you so much, Ron.
Good luck, ma'am.
Thank
Sorry
you.
we had to meet like this, all right?
That's okay, thank you.
Okay, good luck. Okay.
That is hilarious.
Here we go. All right, Joshua Rodriguez. Joshua Rodriguez.
Mr. Rodriguez is here present. Come on up, Mr. Rodriguez.
Okay, good morning, sir. You've been charged with domestic battery, and the court does find probable cause. State record on this gentleman.
One moment, Judge. Joshua Rodriguez.
Ma'am, did you have contact with the alleged victim?
I did, Your Honor. She didn't say anything. though.
Okay.
No record, Judge.
No criminal record. Is there anything from the defense on this gentleman?
Judge, he's been residing in South Florida his whole life. He is 23 years old. He is working. He works at a car wash. He makes about $6 per car that he washes. He's been doing that for the past 2 years. He did attend a local high school, Miramar High School. Due to unfortunate circumstances, he dropped out, but right now he's going to go ahead and pursue. He's trying to get his GED. He does have a separate place to live, separate and apart. We'd ask you to consider an ROR, Judge.
Under these circumstances, the court's going to order an ROR for this defendant. He's got no record. The court looks at the facts of the case, and I kind of understand the circumstances. The court also notes that the alleged victim stated she did not want to prosecute. And the alleged victim was not really the complaining party. It was the police officer who allegedly witnessed this. So I'm going to release him on his own recognizance. However, I will order that for the time being. Do you have any children with Miss Little, sir?
No, sir.
Okay. I'm going to order no contact with Miss Sedasia Little. Do not have any contact with her directly or indirectly. Stay 500 feet from her at all times. That's where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, any weapons while you're on release. Thank you.
Judge, one further request. I know all his belongings are at the property. Can he go one time with law enforcement and retrieve his belongings?
Sure. You can get,
Thank you, Judge.
but the police have to be in a uniform, all right? I know when I was a private attorney, I had a client who tried to get a friend to say he was the police officer and go over there, so I was kind of... Okay, Robert Ramirez. Robert Ramirez. Morning, sir.
He's here present, Judge.
So you've been charged with burglary of a structure and violating an injunction. Court finds probable cause. State, do you have a criminal record on this gentleman?
Yes, Judge. 2010, fleeing and eluding. 2008, possession of marijuana with a VOP. 05, he pled, it looks like a battery after disorderly conduct. 2003, robbery with a weapon, attempted robbery with a weapon, possession of oxycodone. He violated probation, was sentenced to 2 years state prison. In 03, he was arrested on 2 counts of battery. Charges were dropped.
Got it. Got it. Okay, so, ma'am, did you have contact with the alleged victim?
No, Your Honor.
Okay, anything from the defense on this gentleman?
Yes, Judge. And speaking of Mr. Ramirez, he's been residing in South Florida his whole life. At this point, he's unemployed. He's going through the disability process, Judge. So at this time, he has no income coming in. He lives in Margate with his mother. They've been residing at the same residence for the past 3 years. As far as his resources, he has no money in the bank, no property. He worked about a year ago at R&K Contractors. He was in construction. He made about $11 an hour. Judge, we'd ask you to set a reasonable bond as to count 1 and count 2 on Mr. Ramirez's behalf.
Let me ask you, could you, Mr. Afsal, do you have the PC on this? Could you read the last line of the PC, the defendant's 6-year-old daughter? I'm trying to figure out how the 6-year-old daughter got over to the house. Was she living there? It's a fact. Yeah, I don't. Why would his daughter be on scene?
Unless he brought her there.
3 o'clock in the morning. Defendant's 6-year-old daughter was on scene at the time of the incident with permission from her mother. Also recognized with an attempt to cross.
Yeah.
I don't know. I found it just a.
Unless he brought her there with him.
I guess so. All right. Sir, the court's considering the facts.
Judge, I believe as far as if the judge, if Your Honor or the court thinks that he brought the daughter, I believe that is not the case, Judge.
Well,
he was
you
saying.
can tell me, was the daughter, the 6-year-old, staying in the alleged victim's house? Was that it? Or if you don't want to comment, that's fine.
Hector.
But I was trying to.
Hector,
Judge,
don't say
we don't
anything,
want to get
please.
into the issue.
Okay,
we
I
don't want to get
understand.
into the issue.
Understand. I was just trying to resolve that fact. Hold on one second. Okay, sir, the court's going to set your bond based on the facts of the case. There is an injunction, which is in effect that you are to stay away from the alleged victim. It looks like you, willfully violated that. Also, allegedly trying to crawl through the window of the home. The court also notes that you have a prior robbery with a weapon, with a violation on oxycodone also, disorderly conduct, fleeing and eluding the police, and the court notes the concern the court has for the safety of the alleged victim and your willingness to allegedly violate a court order. Count one, the burglary of the structure will be $7,500, and the violation of an injunction will be $10,000. Your total bond today is $17,500. You'll have pretrial release with a GPS monitor. The court will waive the cost of the monitor, and I will order you have no contact with Jolie Garreau. Jolie Garreau, no contact with her directly or indirectly. You must stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns, any firearms, any weapons. You're on release. Thank you.
No picture hospital.
Thank you. Okay, Herman Williams, please. Med reset.
I've been advised of medical loan, Judge.
Okay, we're going to set Mr. Williams for Saturday. How about Kerry Rainey?
Mr. Rain is here present, me. Mr. Rainey, come on up, please.
Your Honor.
The one you gave me the.
Yes, and I'd also like to, I've shown defense counsel, I'd like to provide a copy of photographs of defendants.
Mr. Rainey, let me advise you've been charged with burglary with assault or battery, false imprisonment, and culpable negligence, exposure to harm. What I'm going to do is take about a minute. I need to read some extra material, and I'll be right back with you.
Judge, I understand you have to read the material. Just briefly put my objection on the record with regards to the photographs. The photographs, if somebody's familiar who took the photographs to say these are the photos of the victim in the case, I would have a problem with the court considering that. We don't have that, so I just want at least some type of foundation.
I understand.
And then the person in the photographs must be identified as a victim too. So that's the only thing, Judge.
If I may respond, one, Your Honor, first of all, my understanding of the rules of procedure is that when it comes to first appearance for determination, it specifically states that the rules of evidence need not be strictly complied with. One, two, Your Honor, as the court's aware, and I know this isn't an Arthur hearing, but I'm using it as a comparison because I'm asking the court to make a determination of proof, evidence, presumption, grade. The state is allowed to provide a packet to the court with the evidence that we're relying upon. I am submitting, Your Honor, as an officer of the court, these pictures were taken, as you can see, she was again at the hospital at the time. These are pictures of the victim, Your Honor, and it is evidence provided by the state. We're asking the court to take into consideration.
Judge, all I'm saying is I know I'm going to just want to say that in order they have to move to hold him no bond on count one. They have the burden of establishing proof, evidence, presumption, grade. I understand. I've read the rules with regards to the rules of evidence. They did not strictly comply. My only thing is at least establish some type of foundation or somebody that's familiar with the photographs or somebody that can identify the victim in there. I know the victim. That's her in those photos. That's all, Judge.
And I believe it's also referred in the reports that photographs were taken of the victim's injuries. It's
Steve,
documented.
how did you come to possess these photos?
Your Honor, me personally or the state?
Well, I mean, who gave them? How'd you get them?
Your Honor, Assistant State Attorney Stephanie Newman.
Did she tell you where she got them from?
They were in the file, Your Honor. As you can see, the outer envelope I provided you, it was submitted to by the state to the state by law enforcement as evidence.
Right. Okay, and this was supplied. Okay, so I have the OR number here, which is the offense report number. Hold on one second.
I wasn't even going to say anything. I didn't know that.
Judge, for the, I mean, if this is taken up on at a later date, my specific objection was for foundation authentication and chain of custody. That's it, Judge.
Okay.
And Your Honor, I would just also note for the record in the state's position.
Well, let me just say that I looked at the Fort Lauderdale arrest report number, and it matches from the police report, matches the envelope that I have with containing the pictures that say City of Fort Lauderdale Police Department Photo Lab, photo requisition. This is like a white envelope, and it says here that the date this picture, these pictures were developed was May 25th of 2016. The date of offense is May 24th. So it looks like it was done the next day that they were developed. The OR number matches from the police report to this envelope containing the photos. So.
Your Honor, if I may just briefly, I would also note, Your Honor, and I've reviewed the pictures, it would appear that the injuries the pictures depict would correspond to the description of the injuries in the reports, Your Honor. Would also note you can see the alleged victim wearing a hospital gown, which would also...
Hold on one.
Gown, and which would correspond to the allegation that the pictures are taken at the hospital.
I understand. Just give me I need to read a report. I'll be right back. Okay, so state
Yes,
count
Your
one
Honor.
is a first-degree felony punished by life.
Yes, Your Honor. The state is seeking to foreclose bond, Your Honor, relying upon the reports, not only the initial probable cause affidavit, but the supplemental reports and the photographs that have been provided to Your Honor. It does state that a sworn statement was taken from the alleged victim, in which she did indicate that this was her parents' residence, that Mr. Rainey had no permission to enter the residence, that he entered the residence without her knowing, and upon entering, did commit several acts of violence constituting a battery against the alleged victim, Your Honor. As you can see in the pictures, the documented pictures do support her allegations of the specific acts of violence that were committed against her. Your Honor, there was another witness to a certain degree, the neighbor, when she ran out, it would appear to try to protect the child, Your Honor. I do believe at this point in time that the evidence provided by the state would support a finding of proof evident and presumption great for first appearance purposes.
Any response by the defense?
Judge, I just want the court to just note my prior objections. I believe those objections were overruled with regards to the court considering the pictures provided by the state attorney's office. Secondly, Judge, what's provided to the court, I would ask just based on those facts not to find proof evident presumption great on what's provided before the court.
This
Thank
court
you.
has reviewed the probable. The court's reviewed the supplemental report, which I'm going to attach here too. The court notes that not only did it appears the defendant entered the home unlawfully on the inside, allegedly abused the victim, and used a taser to do it. There's even a witness, a neighbor named Melvin who called 911. And the neighbor, Melvin, basically corroborated what the alleged victim had said regarding her injuries. He even said that this defendant had broken into the house and had a taser. So it's really corroborated by the neighbor. Now, as regarding the photographs the court reviewed, the court understands the defense's objection, and the court doesn't even know if it has to give the photographs very much weight. The court did review them, but the court is finding proof evident presumption great, basically standing on the reports alone, and the photographs were just merely, I see a woman who looks like she's been abused in the photographs, but that's not the crux of why the court's finding proof evident presumption great. The court's doing it on the basis of what the court has read in the reports. So the defendant will be held without bond on count 1, no bond, count 2.
Your Honor, he's entitled to a bond on count 2.
Right, count 2, the court's going to give him a bond.
Sorry.
Does he have any criminal record?
Your Honor, I'm showing in 2016 he was arrested for domestic violence assault against a different alleged victim. That was dropped. In 2015 he was arrested for domestic violence battery, again against a different alleged victim. That was dropped. 2013 he had a burglary of a conveyance and grand theft.
Okay. Regarding the bond on count 2, do you have any comment on that, Mr. Upson?
Yes, Judge, and regarding count 2, he is 22 years old. He's been living here his whole life. At this time, he's not working. He's looking for work. He worked last year at the dollar store, making $8.20. He was laid off. At this time, he's looking for work. He's also planning on enrolling at Hallandale Adult to get his GED. Financially, he has no money in the bank, no property. He lives in Hallandale with his mother. We'd be asking you to set a reasonable bond as to count 2.
Count 2, the court's going to set the bond at $50,000. Count 3, the court's going to set that bond at $2,500. The court will order, and is based on the defendant has been arrested twice for domestic violence. They were dropped, but as the court notes, the statute allows the court to consider domestic cases that have been dropped. The court notes he has a burglary and a grand theft from 2013. The court notes the level of violence, the court's concern for the safety of the alleged victim, the use of the taser, the level of violence, the level of injury sustained, and that there is an independent witness named Melvin. So the court also is going to order there be no contact with Ms. Zander, directly or indirectly. No contact with Ms. Zander, directly or indirectly, sir. You're going to be held without bond until further order of the court.
And, Your Honor, I just want to make a record in case a writ is filed. Since we might have to supplement it, Your Honor, the state provided the court with all the pictures we had in our possession at this time. Obviously, the clerk's office can't keep them and put them into the system. Right. So if a writ's filed, those are the pictures we would provide to the 4th DCA.
If there's a writ filed, you could obviously take that. But the court, like the court says, to be clear, the court did not give really any weight to the photographs. but the court found it on the documents itself.
I understand. Thank you, Judge. Thank you. Your Honor,
Yes.
well, no,
Missy,
never mind.
go ahead.
Let's just
When I
call
call
it.
out your
I think
name,
he's
please
gonna-
line up. We're going to move rather quickly. Please line up when I call out your name.
I'm sorry,
Go
can we
ahead.
call one case at a turn possibly?
What is it?
Derek Bell. I believe he's at Conti.
Derek Bell up at Conti, please step forward.
Judge, I just need to, I just need to place this on the record. I spoke with Mr. Belt early this morning. He's given me permission to waive his appearance
Okay.
for today's hearing. I informed him of the charges. He's being held on high bonds from counts 1 through 86.
Oh, by the way, just before we go any further, the court found proof evident presumption great without prejudice. So I'm not I want to be clear that any subsequent, not trying to foreclose any subsequent motion to be made to review the defendant's release. So I want to be clear about that.
On Kerry Rainey. And what you're saying right now, you're not foreclosing us from
No, on
bringing the
last
issue.
case I found,
Kerry Rainey,
Right.
it's his name. I just need to put it.
I just want to make sure
Because-
today the court does not view this as a final resolution of that issue. Okay. Yeah, no problem. Derek Bell, what are we going to do?
Well,
I think the only thing I was going to ask is, obviously, it's an academic, he can't afford bonds, the bonds that are currently set from 1 to 86.
What are those bonds?
Your Honor, may I approach? I'll show you. Your Honor, everything highlighted is what's currently being held. If I may, when the court's done reviewing,
Well, I see $100,000.
I think that's 10.
Is it 10?
I believe so.
Okay, I see. Let me see here.
Oh, no, I'm sorry, it is 100. I apologize.
See 100,000,
There's no bond.
5,000.
Your Honor, for whatever reason, there's some Burke dwellings that while he may be eligible for bond at this time, are no bond, he's being held no bond on.
I mean, I'm just flipping through here, and I think we're up to 150,000 on some of these.
Your Honor, what I was going to be asking the court, and as you can also see, he's being held on VOPs. All of the cases in front of the court, including the new cases here,
Right.
are in raw court with Judge Backman. What I was going to be requesting the court, because it really would be, oh, and also I'd like to inform the court, all these charges are refiled. They've already all been heard at a first appearance. Your Honor, what I'm asking the court, and I'm only asking this because it really would not prejudice Mr. Bell in any way,
Okay.
is to, you can make a PC determination on the refile and send these back and let Judge Backman determine what the bond should
Well,
be.
Judge, with regards to the criminal enterprise, just basic objection. I think it's going on count 87, 88, just a little excessive with regards to the criminal enterprise aspect of it. I just want to put that PC objection on the record. And all I'm asking the court to do is set some bond.
I mean,
And one of the charges is an armed burglary, Your Honor.
which, do you know which charge that is?
That would be, excuse me, Judge. It's 89 on the.
89?
Yeah, yes, Your Honor. As you can see, Your Honor, if you look at the capias,
Right.
frankly, this is a refile of, it looks like over 20 cases. And really, we've got to provide reports on all these.
I'm gonna find PC on everything and pass it right through to Judge Backman.
Judge, I understand what the court, I understand the court has made its ruling.
Right.
But I'm just going to ask that, if they're going to hold him no bond, then proffer what they're using to hold him
What
proof
I'll do,
evident presumption.
I'm gonna find PC and leave it up to Judge Back. It's
Okay.
academic, and leave it up to Judge
I understand.
Your Honor, what
I
I-
understand what the court's doing, Judge. I just have to put my objection on
And Your Honor,
record,
what
that's
I'm
all.
going to ask the court to do, if you could order on 87, 88, actually, it would be on all the cases that are being held, that they be no bond for Judge Backman to determine what they are.
That's what I'm gonna do. I'm just gonna order the defendant to be held no bond on counts 87 through the last count, whatever the last count is. 165, 166.
It's going to be, I'm sorry, it's going to be through 125. Everything else has a convenience bond.
87 to 125 would be no bond. The rest are up to Judge Backman, all right? Okay, let's call Billy Joe Giron. It's a municipal ordinance case.
Billy who?
Hey, good morning.
That's your
Walking
turn.
in the roadway. He's charged with public urination. All right. So, what do we do about Hey there, sir. Sir.
Hello, Your Honor.
Are you Billy Geron?
Yes, I am.
Sir, were you working before you were arrested?
Oh, actually, I was on my way to look for work.
Do you have any money in the bank?
No, I don't have no money.
Can
I had
you
$20 on.
Can you afford to hire your own attorney?
No, I cannot afford to hire my own
Would
attorney.
you like me to
Your
give you a free attorney this morning to help you out in this hearing?
Honor. I would just like to plead no contest and try to get this over with.
Okay, well, why don't I give you a free attorney? How's that?
All right.
Okay, so I'm going to give you Mr.
I already
Lawrence.
spoke with him this morning in the jail, and as he expressed, he said he wants to resolve it. The only issue is he says he has no money. He would like to see him convert the court cost to a civil lien.
I guess I could do that. Sir, if you want to plead no contest, we can work that out. If you're not a U.S. citizen, what happens today could lead to your deportation. Do you understand that?
Yes, I do. I am a U.S. citizen, Your Honor.
No problem. Do you want to plead no contest and avoid having a trial, avoid having your lawyer defend you after today?
Yeah, I would like to just get this over with,
Okay.
Your Honor.
How do you plead, sir?
I plead no contest.
Okay, I'll accept on withhold adjudication. Good luck. Thank you. We'll,
Thank you.
I'll convert it to a civil lien for this trial. Thank you. Okay, I have one more. Well, it's a state arrest with the MO attached. Is that
Mr.
Highland?
Mr. Highland?
They're for Sheila.
Right.
Mr. Highlands, your President Maine, Judge.
Hey, Mr. Highland, sir, you've been charged
morning.
with the state trespassing.
Oakland Park, old judge, I believe.
Count 1 is charged with state trespassing.
Yes.
Count 2 is an MO. Are you representing him on, how does that work?
No, Judge, well, as the court recalls, the city of Oakland Park is supposed to present Mr. Highland with a defense attorney.
Who do they have? Do we know?
I don't think they do.
Oh, okay, well,
Andrew Newman.
then I'll just probably release the ROR on count 2. All right? All right. Mr. Highland, trespassing on count 1, municipal ordinance on count 2. I'm going to release your ROR on count 2. Now, State, do you have a priors on this gentleman?
1 moment, Your Honor.
Do you have anything you want to tell me, Mr. Highland?
Judge, Mr. Highlands just asking Your Honor if you would consider resolving his case today at time served.
Hold on one moment.
Do you have I'm sorry, Judge, do you have a BCCN number?
It is 623574.
Okay. As far as state priors at a Broward, Your Honor, I'm showing just a couple trespasses last year.
All right, Mr. Highland, are you currently employed?
Yes, Your Honor.
What type of work do you do, sir?
It's roofing and odd jobs, side jobs as well, roofing and...
Do you have any money in the bank?
No, I just started, that's why I want to resolve it
How
today.
long have you lived down here in South Florida?
16 years, it's like 15 and change.
Do you have an address?
Not currently, at large currently,
Okay.
Your Honor.
Sir, I'm going to give you a bond today. It appears by reading this that you continue to walk into traffic and solicit people in their vehicles. And it says here, I quote, the police officer put in here, you said this is like a game. I will continue to solicit here whenever I can make some money. They list all the times that they've asked you to stop doing this, and basically they say you won't stop doing it. They've warned you. They say that you continue to dangerously solicit on the off-ramp, walking into traffic. Numerous occasions have been arrested for doing the same thing.
Okay, I just wanted to give you guys a heads up because
It doesn't look like, and they've tried to give you homeless information to get off the street, and they say you just keep doing it. So I'm going to go ahead and I'm going to set your bond today on count 1 at $250. Count 2 ROR. It's based on, like I say, it looks like an ongoing issue that, and you your two trespasses from last year. All right, thank you, sir.
So he's entitled to a bond.
Hey, Hector, page 5.
And all the
Okay,
other burglaries.
Elvis Hernandez Mota, please line up. Maisha Jeff, Brenda Lee, Izell Jackson, Kevin McManus, please line up. Elvis Hernandez Mata, out of state hold on a felony, sir. You're wanted out of Pennsylvania. That's a no bond hold. You'll be in.
Judge, he needs a Spanish interpreter.
Oh, I'm sorry. Okay. Siete se
Toma
por
asiento,
favor.
por favor.
Hey, if he calls your name, he wants you to line up here.
Okay, what about Maisha?
Maisha North
Jeff?
Broward.
Jeff.
Judge, she was. This is the only thing really. Is she has a county sentence.
Right.
She was sentenced a few days ago, but I think she's been in custody since the 31st of October, and this is a satellite case. I believe she was in custody at the time of the offense. I would ask for an ROR.
Okay, ma'am, I'll release you on your own recognizance on this no driver's license. Thank you.
All right.
How about Brenda Lee?
She's here present at Maine.
Violation of probation, ma'am. You'll be held no bond. You're going to see your judge on the 31st at 8:45 in the morning. This is an oldie. Let me tell you. Let me look at this. Judge Marcia Beach. Wow. This is definitely an oldie. All right, ma'am. Thank you. How about Izell Jackson?
Yes, sir.
Hey, Mr. Jackson. Sir, you have a drug paraphernalia charge on count 1, but you have a parole violation on count 2. So we're going to release you on your own recognizance on count 1. Count 2, that's a no bond hold for parole. All right? Thank you. How about Kevin McManus?
Yes, sir.
Sir, violation of probation on count 1 and 2. You're going to be held without bond. You'll see your judge on the 31st. Thank you.
8:45 a.m. 8:45 a.m.
Let's see, Curtis Plummer.
Mr.
Tony
Plummer, come on up,
Lester.
please. Mr. Plummer, I believe it was an ROR, so I don't think they brought
Was
him.
it? Okay, that's fine. Probable cause is found though. Tony Lester. Where's
Mr. Lester, come on up, please. He's here at Maine.
Hey, Mr. Lester, violating probation. That's a no bond hold. January 31st. Thank you. Okay. Now see, Tiana Joseph, Judith Yasin, and Juliana Biskowski.
Don't sit there and wait, man.
Oh, Judge,
Your Honor.
I've been advised Miss Joseph is a medical reset.
Judge, I understand she's a medical reset.
Right.
What I'm going to ask, Judge, is it's a possession of cannabis, and the facts of the case is that they claim that it's it's just the fact that the officer made a U-turn to contact her. He was doing proactive patrolling, and parts of it bothered me. I'm not arguing PC, but with the court, after she's medically cleared ROR.
Well, here's what I'm going to do. I'm going to go ahead and I'm going to set her for tomorrow. I'm going to go with the weekend judge, talk to her, right? I'm going to med reset her for tomorrow. Judith Yasin. Miss Yasin, count 1 through 4, obtaining controlled substances by fraud. Count 5, 6, 7, and 8 are fraud using someone else's identification to obtain prescription medication. Quick finds probable cause. State, do you have a criminal record on Miss Judith Yasin?
Judge, I believe her mother is going to post her bond.
Well, one moment here.
So.
Yes, Judge, I'm showing. Just want to see the dates here.
Go ahead.
Your Honor, she also has. She's in drug court for obtaining controlled substance by fraud.
She has an open case now.
Yeah, I'm just checking the date here. She posted bond after this occurred, though. But I just want the court to be aware. It looks like there's an ongoing thing.
Let me look here.
She posted bond May 27th of last year, and
Got
These
it.
reports are dated in April.
Okay, ma'am, I'm going to go ahead. I'm going to put your
And Judge, just to let you know, and I know what you were going to order. The pending case is already in drug court, so maybe I'm sure that's where this will go
then you
to.
can take off pre-trial. Sorry about that. Ma'am, your bonds are going to remain $8,000 total. You can bond out. Thank you.
Thanks,
How about
Judge.
Juliana Biskowski?
That's what
North Broward.
Okay. One moment. Ma'am, you've been charged with grand theft auto. Let me ask you, does she have any priors?
One moment, Your Honor.
Ms. Biskowski, how long have you lived here in South Florida?
Hello?
About my entire life, 23 years.
What do you do for work?
I'm currently in between jobs right
sir,
now.
I can't talk right now.
Okay.
Sir,
Because
sir,
of the
I can't
arrest.
talk right now. I'm sorry. I know.
Do you have any money in the bank?
You too.
I don't have any money saved, no.
Okay. Steve, does she have any priors?
I'm not showing anything, Judge.
No? Okay, ma'am. From what I understand, your bond has been posted, but I'm going to order you have no contact with, well, I'm going to do this. Ma'am, I'm going to order your bond's been posted, but by Monday at noontime, you need to report in downtown Fort Lauderdale to pretrial release. I'm going to order your drug tested randomly. Do you understand that, ma'am?
Yes, I do,
Judge,
sir.
If you fail a drug test, ma'am, you're going to be rearrested, put back in jail. Do you understand?
Yes, sir.
Okay, thank
Judge,
you.
will the court reconsider the pretrial release? Her bond has been posted, no prior record.
Ma'am, I'm going to over defense objection. Thank you, ma'am. Okay, ma'am, is there something I can do for you in the front row? Okay, are you,
Your Honor, they're with me.
okay,
Yeah, they're observing.
okay. Where do you go to school? Great, what are you studying there? Great, what about you?
I'm here, but we're taking a business law class.
Okay. All right, well, this is criminal law, but maybe it'll help you in business law. All right, so I took business law too, in college, and I didn't.
Come on now.
All right. Let's see, Tanae Davis, Olivia
North
Todd,
Broward.
Davis and Todd.
This is ever North Broward.
Yes, Davis.
North Broward? Yeah. Okay, Tanae Davis, fraud using
Yes.
someone else's identification and possession of a blank fictitious driver's license. Court finds probable cause. Do we have a criminal record on this person?
No, Judge.
Miss Davis, how long have you lived down here?
Judge, I did speak with her. May
Go
I just
ahead.
get into her ties? She's been a resident of South Florida since 2001. She's currently homeless right now. I would ask the court just to keep the bonds as is and
Ma'am, I'm going to leave
point
the
to Peter.
bonds for lack of ties to the community based on the what I've heard from the defense. Your bonds are going to remain at $1,000.
Judge, would you appoint the PD's office to represent her?
Ma'am, do you have any money in the bank?
She doesn't have any money or own
No.
any property.
Can you afford to hire your own attorney?
No.
Okay, I'm going to appoint you want me to appoint the public defender to represent you? Okay,
Yes.
public defender is appointed. Thank you. Olivia Todd.
That's it.
Olivia Todd, please. Hey, good morning, ma'am.
Yeah.
Ma'am, you're charged with possession of heroin, possession of cocaine, and possession of drug paraphernalia. Court finds probable cause. Do we have a criminal record on Miss Todd?
October of 2016, she had a possession of heroin and drug paraphernalia, but it's not filed. 2016, withheld. 2015, possession of heroin, withheld. 2014, possession of cocaine, drug paraphernalia. 2013, petty theft, without violence. 2012, out of Lee County, prostitution.
Sees a bunch of kids pulling on his door handles.
Okay.
It pulls out a knife, breaks knuckle handle, hits him. These police get to the scene. There was another car, a neighbor's car, where there's an alarm activated. They find the victim's cell phone in his pocket.
All right, ma'am. Ma'am, did you talk to this defendant?
Because nobody saw him.
Olivia Todd. Ms. Todd, are you currently employed?
No.
Do you have money in the bank, ma'am?
No, sir.
Who's going to help bond you out of jail today?
Nobody.
How long have you lived down here in South Florida?
15 years.
There was a fence or anything in the front yard.
All right, ma'am. You have an open heroin case that's unfiled
Yeah,
right
well,
now.
But assuming there isn't.
And you have heroin in the past, cocaine in the past, and you have other things we heard. I'm going to set your bond on count 1 at $2,500, count 2 at
Thank you.
$2,500,
Bad work. I got this.
and count 3 is going to be $100. Your total bond's $5,100 today. Based on your criminal record and the facts of the case, you can bond out of jail. Thank you, ma'am. Ma'am, would you like me to put you in the drug program in the jail if you can't make bond?
And the last one.
No, sir.
Okay, thank you.
Armed burglary.
Okay. Jonathan Hart, Tawan Bennett, Carlos Figueroa.
Hart, stop North Broward.
I know.
Hart? Hey, is this Jonathan Hart? His bond was posted? Okay. Mr. Hart, your bond's been posted. You'll be out of jail shortly. Sir, I want to advise you that while you're on bond, you're not allowed to consume any alcoholic beverages. Do you understand?
Okay, sounds good. All right, so.
On that mic over there. Somebody hit the mic up at North Broward.
Yes, Your Honor, I understand.
Also, sir, within 10 days, if you want to get a temporary driving permit, you need to head out to the Department of Motor Vehicles out in Oakland Park Boulevard and State Road 7 on the southeast corner. There's a shopping mall there, and then that's where the DMV is. You have to go out there, all right?
Yes, sir.
Now, what did you do in the Marine Corps, sir?
I was a forward observer, sir.
Okay, all right. Are you still in?
No, sir. I got out in 2009.
Were you honorably discharged?
Yes, sir.
All right. How long were you in?
6 years, sir. Active reservist.
What was the highest rank or rate you achieved?
E4 corporal.
All right. You know how I knew that? I look at the tattoos. You got the USMC tattoo on you. So,
Yes, sir.
okay. I did 10 years in the Navy. and I had a Marine Corps
Thank you,
drill
sir.
instructor. So, all right, good luck, sir. All right?
Thank you, sir.
Yes, sir.
Thank you.
Tawan Bennett, just for the note.
Judge, Mr. Bennett's here at Maine.
Go ahead. Yes, sir. Hey, Mr. Bennett, you're charged with resisting arrest without violence, altering a license plate validation sticker. The court does find probable cause. Do we have a driving record on this gentleman? All the driving records. Here you go. Thanks. Hold on one moment, sir. Mr. Bennett, are you working now?
Yes, he is, Judge. I have information. He's
Go ahead.
22 years old. He works at the Hyatt Hotel in Miami. He's been working there for about 6 months. He makes $14.25. He lives in Fort Lauderdale. His family also reside in Broward County. He's a registered voter. He's a graduate of Miramar High School 2012. He attended Clark Atlantic University in Georgia, received his BA last year in 2016 in hospitality.
Okay.
Judge, we'd ask you consider an ROR on Mr. Bennett's behalf.
Okay. I'm going to release Mr. Bennett on his own recognizance. Good luck, Mr. Bennett.
Thank you, sir.
Yes, sir. Okay, Messi Carlos Figueroa.
Mr. Figueroa is going to require a Spanish interpreter, Judge.
Okay. Yet to say, Mr. Figueroa. I'm not sure I'm saying that right. Okay, what about Louis Johnson, Mario Sordo, and Michael Imperato? Please line up. Okay, Louis Johnson, theft. Mr. Johnson, court finds probable cause. Do we have a criminal record on Mr. Johnson? He's been known as Anthony Williams. He's been known as Leroy Eustace, Leroy Atkins, William Eustace.
No. All right, cool. All right, bye.
You know what? Is this a failure to appear?
Yes.
Okay. So your bond's $500. Thank you.
Judge, Mr. Johnson is asking if you would consider resolving the case. I believe the incident location was at a public location. There is no outstanding restitution. He's asking if you would consider resolving the
No,
case.
I'm going to leave his bond where it is. Thank you, though. Now, see Mario Sordo. Mr. Sordo.
Mr. Sordo's here, President of Maine.
Hey, Mr. Sordo.
Your Honor.
You're charged with license expired, a couple traffic tickets. You have a misdemeanor. Traffic, no driver's license. Let me look, Mr. Sordo. I see you have an identification card. No driver's license, multiple failures to appear in court. Sir, I'm going to set your bond on count 1 at 100, count 4 at 250 on the failure to appear. Thank you.
Judge, Mr. Sordo is just requesting if on count 4 you would consider an ROR. He says he never received notice. He's telling me it wasn't intentional.
Let me just say this. He has multiple cases where he didn't appear, so I'm going to let it stay where it is. Thank you. Michael Imperato.
That's no problem, Your Honor.
Mr. Imperato, hey, sir, you've been charged with petty theft. Court finds probable cause. I think I remember Mr. Imperato from in the past when I was here at first appearance.
Judge.
Do you have any criminal record? I could be wrong, but I thought he came through first appearance in the past when I was here.
He has a 2016 uttering a forged bills or checks at a Palm Beach.
Okay.
2016 possession of PVP
Where's that?
from here, Broward.
Okay.
2012, he had a burglary that was dropped. 2011 out of aid, resisting without violence. 2010 out of Palm Beach, operating with EWLS.
Okay.
2009 out of Palm Beach battery. 2008 out of Boca possession of cocaine. 2007 possession of cocaine, drug paraphernalia, and
What was 2000, a robbery?
No, 2000. It was a possession of cocaine. 2000, leaving a scene of an accident. 2007 out of.
Okay, anything else?
No, Your Honor.
Got it. All right, are you working at this time, Mr. Imperato,
Yes, sir.
what do you do for work?
I'm a waiter.
Judge, I did speak with him. He's a waiter at restaurant 2201. He's been employed there for, he recently employed there. He lives in an apartment in Pompano Beach where rent is about $600. He's been living at that same residence for 2 years. Judge, I understand that there's prior records. I would ask the court to keep on as it is or ROR.
Does he have any money in the bank?
No, he doesn't. He just paid rent.
Sir, allegedly you went into Walmart, electronic department, concealed security systems in your backpack, and value $248. I note this year. You already have an uttering a forged instrument out of West Palm. You have a FLACA case this year out of Broward. You have a prior battery, prior leaving scene of an accident, multiple cocaine. I'm going to set your bond today, sir, at $1,000. Based on your criminal record, the facts of the case, I'm going to let you bond out. I'm going to order you do not return to Walmart in Margate. Thank you. I see Eric Johnson, John Pendleton, and Richard Pierre Charles.
Mr. Eric Johnson here, present.
We're back on.
No,
We've got a couple students in the class here we were talking to. Eric Johnson, where are you, sir? Okay, sir.
Mr. Johnson's here, President Maine, Judge.
Riding a bicycle without your hands on the handlebar. So that's one of our, probably not as serious matters as we usually see come through here. Count 2 and 3 are murders, possession of cannabis, and theft. There are warrants for your arrest, sir. So count 2 and 3 are $500. Count 1, we're not going to give you a bond on the handlebar issue. All right?
Judge, and speaking Mr. John, he's asking you if you would consider ROR on counts 2 and 3. He said he lives in Fort Lauderdale. He's been residing in the same residence for 7 years. He says he never received notice. Would you consider an ROR?
No.
Or at the very least, he believes a friend of his has $200. If you could go ahead and lower count 2 to $100 and count 3 to $100.
No, the court appreciates your request, but the court's going to leave it where it is. Thank you very much. Now, I see John Pendleton.
Understand.
Sir, DUI, Mr. Pendleton. I'm looking here. Court finds probable cause state. Do we have a criminal record on Pendleton?
One moment, Your Honor.
I'm looking. He's got an E license. I think he has. I'm looking at his driving record. He's got a prior DUI in West Palm, arrest in 2015. He's been convicted of license suspended 1, 2, 3, 4, 5, 6, 7. I'm not sure he was convicted of the DUI there, was he?
One moment, Your Honor. And that was you said that was at a Palm Beach?
Correct.
Could you check that, please?
Make sure I got the right guy. I do.
Yes. I mean, they did charge him first offense.
Yeah, I don't think he was convicted. So, okay.
Don't worry about it. He has, as you can see, numerous DWLSs. Significant priors: Burg dwelling 04, 5-year state prison, habitual offender, cocaine 98, 15 and a half months, cocaine 96, grand theft auto. Numerous DWS habitual offenders. Those wouldn't necessarily show in his record. I mean, his driving record. Burg structured for the mid 80s. End of record.
Okay. Anything you want to say on behalf of this gentleman, sir?
Judge, the only thing I would like to add, I know Mr. Pendleton is residing in Florida his whole life. He does lawn service. He lives in Boca Raton. Judge, he's been living at the same place for the past 6 years. He lives with an elderly roommate who he also helps take care of. He has no money to make no property. What he's requesting, judges, I believe he advised me when he was arrested, he has $300 in his property. I would ask you if you would consider lowering it to $200, because I know here at the jail they take out money for, I guess his the uniform and things of that nature. So I would ask you if you could lower it to $200, Judge.
You know, actually, that's interesting you brought that up, because I haven't done first appearance since I read the case. Do you know there's a case, I think it's up for the U.S., is it up for the U.S. Supreme Court?
No.
About whether or not you can take people's money who've not been convicted of a crime. You're putting the cart before the horse. I think it's going up for the U.S. Supreme Court. Yeah. So, well, we can't resolve that today, obviously, but I'm going to reduce his bond today, even though he's got a prior DUI arrest. I'm going to reduce his bond to $250. All right. There you go.
Thank you, Judge.
Yep.
Okay.
How about Richard Pierre Charles? Okay, sir, you've been charged with disorderly conduct. Court finds probable cause, allegedly being, I'm quoting, drunk individual causing a disturbance at on a public transit bus. State, do you have a criminal record on this gentleman?
One moment, Your Honor. I do. Okay. Just a lot of trespasses, theft, trespass, disorderly intoxication, battery,
Okay,
trespass.
he's got priors along the same lines. Is this something he'd like to resolve today?
At this time, none. I don't think so, Your Honor. He's looking for work. He lives in Pompano. He has a valid address. He would be requesting if you consider pretrial or ROR.
So what's your address?
I used to live in Pompano.
What's your
now
address?
I become homeless now.
All right. Would you like to resolve your case? You can plead no contest. You're out of jail today. You'll pay minimum court cost. You want to do that?
Yes, sir.
Do you understand?
But I don't have no money, no.
We'll send you a bill. We'll send you a bill in the mail. All right. All right. Do you understand? We'll send you a bill in the mail. I'll give you 6 months to pay. Do you understand?
All right. Yes, sir.
Do you want to plead no contest today?
Yes, sir.
How do you plead?
I plead no contest.
Do you understand? You're not going to have a trial. You're not going to have your day in court. The case is over with right now. Do you understand that?
Yes, sir.
Okay. I'll accept your plea. I'll withhold adjudication. Give him 6 months to pay the minimum court cost. And just for the record, he's got a history of these type of charges. So we're not marking up a clean record. Thank you, sir. How about Pablo Rocha, Brian Rahan, and Alberto Amparo? Mr. Pablo Rocha, you've been charged with trespassing, sir. Court finds probable cause. Allegedly previously trespassed from a bus stop. You said that you're not allowed to go back to the bus stop, sir. All right. Are there any priors on this gentleman? Mr. Rocha, you're 20 years old. Are you working now?
Some days, some not. Mostly not, though. I'm not getting many
What do
hours.
you do for work when you work?
It's J&J Amusements. I run the rides for the little kids.
Who do you live with?
Right now, nowhere.
You don't
I'm
have
homeless.
You're how long have you been homeless?
On and off like 2 years.
Do you have any family here locally?
And like Lee County, but that's the closest.
All right. State, does he have a criminal record?
Trespass last year, failure to leave property, and disorderly intoxication last year, theft last year, trespass last year, theft 2015, theft 2014.
So would you like to just resolve it today and plead no contest?
Yes, sir.
I mean, you've got multiple trespassing thefts. Sir, I'm just going to ask, don't return to that bus stop, all right?
Yeah.
Just don't
Yes,
go back
sir.
there. Sir, you understand pleading no contest. You're not going to have a trial. You're not going to have your day in court. It's wrapped up right now. Do you understand that?
Yes, sir.
How do you plead to one count of trespassing?
I plead no contest.
I'm going to accept it, withhold adjudication, and they'll give you 6 months to pay the minimum court cost. Thank you.
Okay.
Carlos Figueroa. Sir, please clearly refer to translate from English to Spanish, Spanish, English truthfully, and to the best of your ability. Okay, this is Figueroa. Good morning, Mr. Figueroa.
Buenos días, señor Figueroa.
So you're here for trespassing.
Señor, usted está acá por entrar ilegalmente en una propiedad.
It's alleged that you keep going back to a restaurant.
Se le acusa de regresar repetidamente a un restaurante.
They said you're panhandling in front of the restaurant.
Dicen que usted está mendigando afuera del restaurante.
They don't want you to go back there.
Ellos no quieren que usted regrese ahí.
State, does he have a criminal record?
I just need his BCCN
Vamos a
number.
averiguar si tiene antecedentes.
704376. Sir, what is your address?
Señor, ¿cuál es su dirección?
Winston Mayer. Winston Mayer de Polo.
Repita, por favor.
Return home.
Judge.
Sir, tell us what your address is.
Señor, díganos cuál es su dirección.
Return home. Tengo mi teléfono. No sé.
Judge, I don't think he knows the exact address. He advised me he lives in Wilton Manors in a retirement home.
Judge.
Go ahead.
Dice vivir en Wilton Manors en un hogar para ancianos, ¿correcto?
Sí.
He had in 2013 an unlawful use of false name and trespass. He went through Judge Loren's division.
He is on disability, Judge. He's been residing here for about 20 years. He's unemployed. He did tell me that he's been living at this retirement home, I believe, in Wilton Manors for the past 15 years.
Let me clarify. Do you live at 401 Southeast 12th Court?
Señor, para aclarar, usted vive en el 401 Southeast 12th Court. 12 Court.
Sí.
Yes.
I'm going to release you without bond.
Voy a liberarlo a usted sin fianza.
But let's be clear about one thing.
Pero quedemos claros en algo.
You are not allowed to return to the Tortilleria Mexican restaurant.
Le queda prohibido regresar al restaurante mexicano Tortilleria.
Okay.
You cannot go back there.
No puede volver ahí.
Thank you.
Okay.
Gracias.
Thank you. Gracias.
Messi Elvis Hernandez Mota.
What page, Judge? Judge, I believe we have two other individuals who speak Spanish, Judge.
I understand. Hernandez Mota.
Hernandez Mota? Hernandez Mota.
Is it? North Broward, do you have Hernandez Mota?
Page 4, Hernandez Mota. Oh, wait, that was
Hold on a
here.
second.
Hold on.
Yeah, I don't think we have him, Your Honor.
You don't?
Not at North
No,
Broward.
Judge, he's here at Maine. He might have stepped to the restroom.
You guys, you have him there for Spanish.
Ven aquí, señor. Judge, we have Mr. Francisco Rivera. I believe it was reset from yesterday. And speaking to him further, Judge, he advised me that he was speaking with his mother, and he advised me that his mother hired an attorney for him, but he does not know the name of the attorney or anything like that.
Señora juez, me informa el acusado que al hablar con su madre ha contratado a un abogado particular, sin embargo no sabe el nombre del abogado ni ninguna otra información al respecto.
The only thing I could suggest, Judge, is he can give me the phone number of his mother. I could call him and find out that information of his attorney.
Lo único que puedo sugerir, señor juez, es que le puedo pedir el número de teléfono de su madre, entonces puedo llamar a la madre y obtener esa información.
Judge, I just want to make sure that he understands the interpreter. He can clearly hear him, and that's
Well,
it's
he
an
also
important
didn't need an
hearing.
interpreter yesterday.
He did. He needed an interpreter.
He did? I didn't think he did. Okay.
Sir, can you understand what we're saying?
Señor, ¿usted entiende lo que estamos diciendo?
Okay.
Yes.
All right.
Your Honor, and I thought the whole reason that was explained to him yesterday for resetting it was to contact his mother.
I know. But
And they allowed him to. He said he made a phone call, and when he was speaking to his mother and he was getting the information, the line just basically
why don't you call
gave
up?
out, and then he.
Yeah, just give the
Okay.
mom's number.
Simplemente
Okay.
denos el número de la madre.
Okay, Judge, I have his mother's phone number. I will, if we could put on recall so I can go to the phone
Got it.
call, or do you want me to?
No, just
Okay.
call over.
Okay.
Simplemente llame.
Just give us one moment. We're going to go side. We're going to take about a 5-minute break. We'll be right back.
Oh, and Elvis is here, Judge.
I got it. Okay. We're back on the record, and Francisco Rivera, we're just going to put that aside for a few minutes, all right? Put that right there. And then Elvis Hernandez Mota. Good morning, sir.
Buenos días, señor.
Sir, you are wanted out of the state of Pennsylvania
Señor, a usted tiene orden de aprehensión en el estado de Pensilvania
for a very serious matter,
por un asunto muy serio.
and the state of Pennsylvania has indicated they want to extradite you back there.
Y el estado de Pensilvania nos ha indicado que desean extraditarlo para que usted sea devuelto ahí.
You will be held without bond.
A usted se le mantendrá bajo custodia sin fianza.
You'll appear before another judge in this circuit,
Comparecerá ante otro juez en este mismo circuito.
and that judge will discuss the extradition matter with you.
Y ese juez discutirá con usted el tema de la extradición.
You'll be held without bond until further order of the court. Thank you.
Usted permanecerá en la cárcel sin fianza hasta que se ordene lo contrario. Gracias.
Thank you. Okay. Any more Spanish speakers?
Just the one, I believe that was on recall, Judge. His name was
Who got that?
Francisco Rivera. And besides that, I don't think nobody else requires Spanish.
Okay. Brian Rehan, can you just stand by just for a few minutes, or?
Like 5 minutes.
Yeah. Okay. Thank you. Brian Raham.
Yes, sir.
Sir, count two is a warrant on a burglary, an armed burglary, and is that a order signed by Judge?
No, Your Honor, it's a direct file. Your Honor, the state is going to be seeking to foreclose. Your Honor, if I may proffer, Your Honor, the state believes that Mr. Rahim is a danger to the community. He's being held on count one for murder in the second degree. That has also been direct filed, and the court found proof evident or presumption great when that case first came through.
Okay.
Your Honor, relying upon the affidavit, I believe the evidence does satisfy a standard of proof evident or presumption great. Mr. Rahim was seen on video surveillance first approaching the victim's residence, knocking on his door. When there was no answer, he went around to the back and made entrance through, one moment, Your Honor, the rear patio door and west side window, and it is documented that both were smashed in, Your Honor. He's seen entering the residence, and approximately an hour later is then seen leaving the residence with a black knapsack that it appeared to be full, that had property inside it. The alleged victim, upon reviewing the video surveillance, identified Mr. Rahim. He has personal knowledge of who Mr. Rahim is. It's noted that he's worked for him in the past and has been to his residence on more than one occasion. And, Your Honor, the alleged victim documented that among the property stolen from his home was a silver Derringer 22 handgun. Your Honor, I would also note that, as the court is aware, since this is a filed felony charge, by a requirement of law, the state would have had to have taken or received a sworn statement from the alleged victim.
Okay. Any comment by the defense?
Yes, just briefly, Judge. Just in order to establish proof evident presumption great, the state has a clear burden of establishing that. What's before the court, and what I could gather is I have an affidavit from the clerk's website of the incident report. So all I had reviewed was the incident report. In order to establish proof evident presumption great, I agreed that the court can consider sworn affidavit, probable cause affidavits in determining whether or not there's proof evident presumption great. What's before the court and what I've read is solely to establish probable cause and not proof evident presumption great. Even though there may have been sworn statements taking in the case, that's not provided to the court. So in light of that, Judge, I would ask the court not to find proof evident presumption great and to set a bond in the case.
Okay.
Your Honor, if I could just in case of risk I'm not trying to. Your Honor, I would rely upon Brackett v. State and Preston v. G Brackenby states out of the 4th DCA specifically stating that not that the court can rely on an affidavit, but that the state may rely upon an affidavit in satisfying proof, evidence, presumption grade. The court in Preston v. while they did not find proof, evidence, presumption grade, only made that finding because they found that the evidence contained in the affidavit did not satisfy proof, evidence. Not that a use of an affidavit in and of itself could not.
Right.
Nobody's arguing that. I'm just saying what's in the affidavit is what matters.
I got it. The court is going to find proof, evident, presumption grade. The court notes that the alleged victim, the homeowner, knew this defendant from contacts in the past, very familiar with him, and there's surveillance video that shows allegedly the defendant going in the home, the defendant exiting the home. The defendant exits the home with the backpack, cash, several other things. The alleged victim realizes that his handgun is stolen, and it was there before the defendant went in and smashed the window. It was gone when he left. Positively identified the defendant. The court relies on the attached affidavit. The defendant will be held without bond. Court finds proof, evident, presumption grade.
And we obviously, you're in abundance of caution as for no victim contact, Judge.
No contact with the alleged victim.
Thank you, Your Honor.
Is Martin on his way over?
I called his office. I'll call his office again to see if they come.
You know what? I can reset it for the afternoon. Do you have somewhere else you have to be?
Your Honor, can we approach briefly? There's only one issue I would have with that.
You want to stand back up there? May I see Francisco Rivera?
Mr. Rivera is here present, main judge.
Mr. Rivera.
Señor Rivera.
I have attorney Jonathan Marn on the telephone.
Tengo acá al abogado Jonathan Marn.
Apparently, your family has contacted him.
Parece ser que su familia lo ha contactado a él.
But he has not officially been hired to represent you.
Sin embargo, a él no lo han contratado oficialmente para representarlo.
He will stand in for this hearing.
Él va a hacer el favor de estar para esta audiencia.
But he may or may not be your attorney after this hearing, depending on whether your family officially hires him.
Pero no se sabe si él va a ser su abogado o no después de esta audiencia, porque eso depende de que su familia lo contrate.
Sir, you've been charged with burglary of a dwelling armed with a firearm.
Señora, usted se le acusa de robo a mano armada en una morada.
Grand theft of a firearm.
Así como hurto mayor de un arma de fuego.
Grand theft.
Hurto mayor.
Resisting arrest.
Resistirse a la detención.
You have a probation violation.
Y tiene también una violación de su libertad condicional.
Sir, are you seeking to hold him without bond on count one?
Yes, Your Honor. May I proffer?
Se está solicitando mantenerlo bajo custodia sin fianza.
Your Honor, according to the probable cause affidavit,
Su señoría, según la declaración jurada sobre causa probable,
The author of the affidavit, an undercover detective, was advised that two males were going into residential yards.
al autor de la declaración jurada, quien era un detective trabajando de manera encubierta, se le informó que dos varones se dirigían hacia residential yards.
Other undercover detectives responded to the scene and observed
Otros detectives encubiertos respondieron, fueron a la escena y observaron
Mr. Rivera and another gentleman entering to a property on 17th Street.
al señor Rivera y otro caballero entrar en una propiedad en la calle 17,
Going into the fenced-in backyard.
entrando a la zona del patio que se encontraba enrejada.
They were then, the detectives and law enforcement took tactical positions.
Los detectives y otros agentes de policía luego asumieron posiciones estratégicas, tácticas.
And observed Mr. Rivera and his co-defendant exiting the front door of the residence.
Y observaron al señor Rivera y al coacusado salir por la puerta delantera de la residencia.
Upon Mr. Rivera and his co-defendant seeing law enforcement, they fled
Al ver a los oficiales, el señor Rivera y el coacusado huyeron,
back to the rear of the yard.
dirigiéndose hacia la parte posterior del patio.
While chasing Mr. Rivera, law enforcement observed him discarding a .380 caliber P380 firearm.
Mientras se disponían a perseguir al señor Rivera, los oficiales de policía lo observaron tirar o descartar un arma P380, arma de fuego.
Law enforcement recovered the firearm.
Los oficiales recuperaron el arma de fuego.
And the owner of the property at 3309 Southwest 17th Street identified the firearm as his property.
Y el dueño del domicilio ubicado en el 3309 Southwest calle 17 identificó el arma de fuego como de su pertenencia.
Nothing further, Your Honor.
Okay, this court will find proof evident presumption great
Bien, se considera que existe prueba evidente, presunción alta en este caso,
as to armed burglary
para el delito de robo a mano armada.
based on the attached affidavits and the presentation by the state.
Con base en las declaraciones juradas que se han adjuntado, así como el informe presentado por la Fiscalía.
Grand theft of a firearm on count 2 will be $5,000 bond.
La fianza para el hurto mayor de un arma de fuego, que es el cargo número 2, será de $5,000.
Count 3 grand theft will be $5,000.
El cargo 3, hurto mayor, $5,000 de fianza.
Count 5, he'll be held without bond.
Para el quinto cargo se le mantendría en custodia sin
Count
fianza.
4 will be $100.
Y para el cuarto cargo serían $100 de fianza.
We just asked for no victim contact.
No contact with the alleged victim.
Le queda prohibido tener contacto alguno con la supuesta
Thank you, Mr. Martin.
Gracias.
Yes, thank you.
And Your Honor, I'm sorry, and the state concedes that Mr. Marn and the defendant has the absolute right, should they choose to seek an Arthur hearing, any signed motion.
The finding of proof evident presumption great is without prejudice. Mr. Martin, you can seek to have it reviewed at the trial level, all right?
Y señor Marn, el hallazgo de que
Thank
existe
you.
prueba evidente, presunción alta, se hace sin perjuicio de que el señor Marn lo pueda apelar a nivel de juicio.
Thank you.
Gracias.
Alberto Amparo, I don't think this is Spanish. I doubt it.
No, it's not, Judge.
Okay, thank you. Aggravated battery causing bodily harm, aggravated assault with a deadly weapon, burglary of dwelling structure, conveyance armed, grand theft, and battery.
And Your Honor, the state is not seeking a foreclosed one because I don't believe at this time, I can't, Your Honor, I can't make an argument for proof evident or presumption great for armed burglary of a conveyance. And the reason being, Your Honor, one, the incident.
Sure, there's even PC for the armed burglary of the
Well,
is there?
One, the first incident was an attempt.
Right.
I would argue that there is evidence that a burglary did occur.
Right.
I think I think you can make an argument of probable cause that he would have been in possession. There's nothing to indicate he wasn't. But that being said, if the court is inclined to find attempted armed burglary. I'm fine with that. Either way, it's bondable.
Count 3, the court's going to find an attempted armed burglary of a conveyance attempt. Okay, and then
Oh, and Your Honor, just for record purposes, I did check. Frankly, I went on Google and checked the residents listed. There's the front yard was not. It's not enclosed.
Okay.
So there's no issue of.
Got it. Okay, so the court's going to find probable cause on 3 for an attempted burglary, armed burglary. Now, does he have a criminal record?
He does, Your Honor. He has juveniles on. Mr. Paz.
He's got juveniles. You want to call over there?
Take it up.
Stand by.
I'll make it brief. Your Honor, Your Honor's familiar with the allegations. I am concerned for the safety of the community. It appears Mr. Amparo, upon the owner of the property trying to stop him from burglarizing him, used a weapon that could have caused serious harm against him. It also appears, while he's only been charged with one kind of burglary, that this was a pattern of conduct in the area with his co-defendants. It looks like they were at least broke into one car and tried breaking into several other cars.
Right, and the court notes the defendant allegedly used brass knuckles on someone.
It looks like it was brass knuckles, the handle of a knife.
Right. Okay. Anything you want to say on behalf of this defendant, sir?
Yes, Judge. He's been residing in South Florida his whole life. He is 18 years old. He's currently employed. He works off and on whenever he's called in order to do construction. He gets $14 an hour when they call him. Financially, has no money in the bank, no property. He lives in Hollywood. He lives with his mother at a duplex. He's been residing with his mom for the past year at that specific location. He helps his mom with his chores, Judge. We'd be asking you to set a reasonable bond as to Mr. Amparo.
Got it. Sir, based on the level of violence, the alleged use of a weapon during this incident, the court's concerned for the safety of the community and noting you have a juvenile record. The court will set your bond on count 1, aggravated battery at $10,000, aggravated assault at $5,000, burglary, attempted armed burglary, $5,000. 4 and 5, grand theft and battery at $1,000 per count. Your total bonded is $22,000. Sir, the court also is going to order that you have no contact, directly or indirectly, with Angela Marino or Itavia Emiscar and Victoria Tupasi.
It's Victor Tupasi Ponky.
Tupasa Ponky and Jessica Mantooth. No contact with them directly, indirectly, or any of their property. You're not allowed to possess any guns, any weapons, any firearms, any ammunition while you're on release.
I'm sorry, Your Honor. Also,
Yes,
just
Judge.
based
Thank
on
you.
the level of violence and the other alleged conduct, we would be asking for a GPS
I'm going to
monitor.
order a pre-trial release GPS monitor. It will not be a lockdown. He's allowed to move freely. Thank you.
Thank you, Judge.
10.55 in the convenience bonds.
10, 5, 5, and 1,000. Thank you. Dean Thorpe? Yes, pre-trial release GPS, waive the cost of GPS. Dean Thorpe?
Mr. Thorpe is here, President Main Judge.
Burglary with a battery.
Your Honor, I spoke with the manager of the tow company this morning,
Right.
who also, through whom I spoke with Mr. Solomon. Your Honor, we are not going to be seeking a foreclosed bond. I just want to briefly put on the record, Your Honor, my understanding is, one moment, you said he has no record, he's not on the list. Does pretrial have any history? I asked you about this. Oh, wait, hold on. Well, I'm sorry. I was looking.
Tell
Wait,
me
never
about
mind.
Mr.
Your Honor,
Thorpe.
Your Honor, he has no record.
Got it.
And Your Honor, I can tell you, based on the allegations of that, I have no objection to a bond. The only thing that the alleged victims asked me is they do want him in order that he stay away from all county towing.
What? Tell me about Mr. Thorpe.
Yes, Judge.
Go ahead.
He's been residing in South Florida for the past 6 years. He is employed. He works at Tech Systems, installing alarm system and cameras. He's been doing that for 1 year. He makes approximately $22 an hour. He lives with his girlfriend and his child, who's 5 months old. Financially, he has no money in bank, no property. He lives in Lauderhill. His rent is about $750 a month. He lives there with his father, who also shares in half the expenses. He's been residing at that location for 3 years. Judge, considering he has no priors, Judge, we'd ask you to consider that in determining a reasonable bond on behalf of Mr. Thorpe.
Okay. Hold on one moment. Let me ask you, Mr. Thorpe, I want to ask you, how long have you lived down here in South Florida?
About 6 years, but legally I'm going like 3 years, for 3 to 4 years.
How old is your child?
The last 5 months old.
5 months. Do you have any other children?
Yes, one of them.
How old is the other child?
10 years old.
Does the child live with you, the 10-year-old?
No, she lives back where I'm from.
Okay. What did you do before you got in the security business?
I've been doing security business for over 20 years now.
Okay. I'm going to release you on your own recognizance today.
They would object to a straight ROR.
Stan,
I think some bond is appropriate, considering that the state's...
The court considered the context of how this allegedly occurred. Frankly, we've seen other people try to self-help their car out of the tow lot. It's not legal, but I see the man's 39 years old. He's got no criminal record, and the court's going to just chalk this up today as perhaps a moment of poor judgment. I don't think the defendant's a danger. Sir, I'm going to order that you do not return to all county towing. If your car is still there, I assume it's still there, have a third party go there and get your car out. You may have to do power of attorney. I don't know how that works, but don't go back there, all right? Don't call them. Don't go back there. I don't want you to have any. Do you have to have a gun in your possession doing your work? Okay. Then you're not allowed to have a firearm in your possession while you're out on release. Thank you.
Thank you, Judge. Hold on 1 second. Let me just explain to him the no contact so he really gets it, Judge. Hold on.
Here we go.
Let's go so we can have some lunch.
All right. Okay, Joshua McCommon.
Yes, sir. Present, Judge.
All right, grand theft, sir. Court finds probable cause. And state, do we have a criminal record on Mr. McCommon? Dyson handheld vacuum cleaner at $149 and another vacuum cleaner at $499. Go ahead, state.
Felony theft, 2016. Dealing in stolen property, 2015. Heroin, 2014.
What happened in 15?
Dealing in stolen property.
Got it. Okay.
Heroin 2014, grand theft 2014, 2 counts of grand theft 2012, false ownership info on a pawn item and theft 2012, violation of a domestic violence injunction 2012, battery 2010, DUI 03, and a record.
Got it. Anything you want to say by the defense?
Judge, he's just advised me financially he can't afford post bond.
Sure. I understand. How long has he lived here in South Florida?
His whole life, Judge. He's actually lives with a roommate. He lives in what city?
451.
No, what city?
Margate.
Margate. He lives in Margate with a roommate.
Does he have family here?
Yes.
Is he working?
Yes. Home remodeling.
Do you own any land or property in South Florida?
No, sir.
Do you have any money financially available to bond out with?
No, sir.
Got it. So I'm going to set your bond today at $5,000. Just this year, you already have a felony petty theft this year, a dealing in stolen take that back. 2016, a felony petty theft. The year before, a dealing in stolen property. The year before, a grand theft. A couple years before that, 2 more grand thefts and a petty theft. Prior battery, DUI, and mix in 2014 a heroin. Looks like ongoing criminal activity. Sir, your bond's $5,000. Do not return to target. Thank you. How about Daniel Jean?
Mr. Jean's present here at Maine.
Sir, windscreen violation, license suspended, cannabis, and possession of oxycodone. Court finds probable cause. Do we have any priors on Mr. Jean?
One moment, Judge.
Got no driver's license from what I can see.
I don't think there's a bond attached to it.
What?
So ROR and the ROR?
Yeah, we'll ROR that one. Tell you, not a whole lot gives past Mr. Oswald.
No priors, Judge.
Correct. No.
Go ahead.
No priors.
No priors. This gentleman has no criminal record. Sir, do you still live on 39th Street in Pompano?
Yes.
You do? Do you have an apartment? Is there an apartment or unit number there?
Hold on a second.
39th Street is the house number.
Okay, got it. How long have you lived there?
That was that was the last house my dad bought. I would say 2 years.
Do you
a
still
little
get
more than 2 years?
you still get your mail there?
Yes.
Okay, I'm going to release you on your own recognizance today, but I'm going to send you to pretrial release. You have to be there on Monday, and you're going to be drug tested randomly. Thank you. By 12 noon on Monday, report to pretrial release. Thank you. How about
Okay, make sure there's the
Christopher
map to pretrial.
Ganori,
Make sure you
Neil
get
Burke,
there by Monday
Lucas
before noon
Perez.
p.m.
I'm going to be drug tested.
Christopher Denori's here present.
Sir, count 1 is grand theft. Court finds probable cause. Your bond's $1,000. Count 2 is a violation of probation, no bond. Thank you. How about Neil Burke?
That's it. Neil Burke, come on up.
Dealing in stolen property on count 1 and 2. Dealing in stolen property via the internet on count 3. Court finds probable cause. State, does he have a criminal record?
DUI 2010, resisting without violence.
DUI and resisting arrest. You want to say anything on behalf of this defendant's ability to post bond and ties?
Not at this time, Judge.
Sure, the court's going to assume you have no money and excellent ties, and we leave your bonds at right. I'm looking here. Confidential informant provided information. Defendant involved in the purchase of brand new stolen high-end power tools from an organized group of thieves known as boosters. Stealing from Home Depot and Lowe's.
I don't have money.
So I'm going to go ahead and set your bond based on your criminal record, the amount stolen, the facts of the case, $3,500 on count 1, $3,500 on count 2, $1,000 on count 3. Thank you. Lucas Perez.
He bonded.
He bonded. Got it. How
Christopher
about
Frazier, come on
Christopher
up.
Frazier?
Judge, I know in count 2 it says VOP no bond hold. He said he was in front of Judge Uson, and Judge Uson terminated his probation. If Mr. Lunder can look in Odyssey and verify.
Okay, sir, count one's a license suspended habitual. Let me look here.
No, what he said was upon payment and termination. What I can see here, upon payment of restitution, probation automatically terminate. Doesn't look. Well, hold on. Yeah. And the allegation is here he didn't make restitution payments, so it couldn't have been automatically terminated.
Okay. So, sir, count one, I'm going to reduce that bond on count one to $100, but you're going to be held without bond on count two. And you'll see your judge on the 31st at 9 a.m. Thank you. How about William Serra? William Serra.
Mr. Sarah's here, President Maine.
Mr. Serra, good morning. You have the right to remain silent. If you give up that right today, whatever you say can and will be used against you. Please do not comment about the facts of the case. Everything's being recorded. Now, Mr. Serra, 3 counts of aggravated assault with a deadly weapon, specifically a motor vehicle. Count 4, grand theft auto. 5, fleeing attempting to elude the police. 6, fleeing with disregard to safety of people or property. 7, driving on a suspended or revoked license. And 8, leaving the scene of an accident with injury. The court finds probable cause to each and every count. State, this defendant have a criminal record?
One moment, Your Honor.
I'm looking at the defendant's driving record. It reflects that Mr. William Justin Serra has no driver's license. It does appear that he has an ID card. And I do see he's been caught driving several times. In 2016 in Dade County, he was convicted of leaving the scene of a crash. It was not a conviction, it was a withheld adjudication. He's got prior drug charges, I can see. Okay, state.
Okay. Well, first off, I'm showing he's got a theft out of Dade 2016. Loitering or prowling out of Dade 2014, possession of controlled substance and marijuana 2014 out of Dade. He currently has injunction order of protection against stalking in place against him, non-expiring.
And where's that out of?
Dade County, Your Honor.
What year was that from?
It was issued 2016, from what I see here. Your Honor, I'm also showing arrests in Dade County for aggravated stalking, aggravated assault. They were domestic violence battery, and all those charges were dropped.
What year was the DV battery?
I'll just go through all of them. The stalking was from 2016. The aggravated assault was from 2016. And the battery that was dropped, obviously, was 2014.
And they were all DVs?
It appears that they were all domestic violence in nature.
Got it. Those are all out of Dade County, right?
Yes. I think there's one more. Maybe he bought it up too.
Okay. Anything the defense would like to say regarding Mr. Serra?
Judge, he's been residing in South Florida his whole life. He's 28 years old. He's currently employed. He works at the Boston Market. He's been working there for the past 6 months, making $9.50 an hour. He has no money in the bank, no property. He did attend Hialeah High School, and at this time, he wants to try and pursue obtaining his GED. We would be asking you to set a reasonable bound as to counts 1, 2, 3, and 6, Judge.
Okay, I have on the police report that he's at large in Hialeah. Does he have a current address?
At this time, no, Judge.
Okay. All right.
And, Your Honor, I would just note, my concern obviously would appear from these allegations that he put the lives and safety of numerous officers, and I would imagine other people in traffic or on the roads at danger by
This
his
appears,
acts.
it's alleged the defendant allegedly put his vehicle in reverse and tried to run into one police officer. And then it says they ordered him to stop, put the vehicle in park. He put his hands in the air and then allegedly put the car back in drive and allegedly accelerated toward 3 more officers. And the vehicle allegedly was stolen out of Miami-Dade earlier in the day. And while the defendant was leaving, he allegedly ran into another car.
We have, and that was the thing, they located him 2 days, they lost him, located him 2 days later, and he tried to flee again.
The court's concerned with for the safety of the community, not only this defendant allegedly trying to run over 3 or 4 police officers, I'm not sure, but it also, the defendant has a history of leaving the scene of a crash because that's noted on his driving record. The court also notes that the defendant seems to be transient. He doesn't have a good address in South Florida. The court notes he has a lengthy criminal record: theft, loitering and prowling, drug charge. He also has a stalking injunction against him out of Dade County from 2016. So a judge down there is already determined that he represents a danger or harassing somebody. So the court is going to consider that, and the court also notes he's had a violent charge, 2 violent charges: aggravated assault, domestic violence related, domestic battery dropped in Dade County. So the court is going to set, and based on the very nature of the charge, the court also believes he is a certain high risk for not showing up in court. The fact that he was fleeing from the police. Count 1, the court's going to set that bond at $10,000. Count 2 is $10,000. Count 3, $10,000 on the aggravated assaults toward the police. Grand theft auto, he's got a prior theft. Court's going to set that bond at $5,000. Fleeing the police, he's got a prior leaving the scene of a crash. Court's going to set that bond at $5,000. Fleeing and disregarding the safety of persons, that'll be $5,000. ROR, count 7, and $1,000 on count 8. So I'll add up your bond for you, sir. $30,000, $40,000, $45,000, $46,000 total, and you can bond out of jail.
Your Honor, we'd also ask for a GPS monitor.
I will. I'll order a pretrial release GPS monitor. I'll waive the cost.
Judge also, oh, I'm sorry.
I'll waive the cost of that. All right, that'll be level 2. All right?
Judge, also, we'd be asking for if you could allow us to photograph Mr. Sarah's injuries that he suffered.
The court will order that. Thank you.
Thank you.
No
they're law. It's kind of.
All right, Walter Roberts, Jeffrey Parker, and Gregory Campbell.
Walter Roberts, I've been advised, is a medical reset.
We're going to set Walter Roberts medical for Saturday. Gregory Campbell.
Gregory Campbell, I've been advised, is a medical loan, Judge.
We're going to set him for Saturday, medical reset. There you go.
Judge, we have one more person here. What's your name?
Curtis Palmer.
Curtis Palmer.
Hey, what happened? What about Jeffrey Parker? Is he still med reset?
Oh, Jeffrey Parker, I've been advised, medical loan.
Okay.
Who's this gentleman right here?
Curtis Plummer, sir.
Curtis Plummer.
Didn't I take care of Curtis Plummer earlier? Can somebody hand me Curtis Plummer again? Got it. Wasn't that an ROR?
That's the ROR.
Yeah, he was released ROR. You're going to be out of jail shortly, sir. All right?
Yes, sir.
Thank you.
Okay.
That's a wrap.
See each other at 1 o'clock.
Sure, I'll do that. Okay, everyone, you'll be back at what time? 1 o'clock today?
1 o'clock.
That's going to be Judge Florence Barner. So I appreciate the 2 days. It was good being in here for the last 2 days, but I'll probably not be in here for a while longer again. It was a pleasure seeing my old friends. And I hope everyone has a nice weekend. All right?
You know,
Thank you very much.
everybody that says they're not, every judge that says they're not going to be back in here for a while, somehow
Unless somebody,
they end up, karma works out funny that way.
yeah. Yep. Okay, everyone, thank you. Have a very nice weekend. It's good seeing everyone. All right? And I'm out from 2:35. Thank you.